Hi there. My name is Emily Newman. I'm the managing partner of Reddy Neumann Brown P.C. And with me today is Stephen Brown, also a partner at Reddy Neumann Brown P.C. We are both immigration attorneys helping businesses and their employees navigate the U.S. immigration process. And today we want to talk about STEM OPT requests for evidence. This is a situation where F1 students who've already received their 1 year of optional practical training, and if they have a STEM degree and are working for an E-Verify employer, complete the 983 form, and then they can file for a STEM extension. So those are usually done by the student on their own. It's a relatively straightforward process, but we are seeing more and more requests for evidence coming on these applications. And so we wanted to do a quick video to talk about it, let you know that it's normal, but what to be aware of and to think about when you're responding to that. So Stephen, can you run down what the issue is that they're raising in these requests for evidence and what they're asking for?
Yeah, so certainly. So, at first glance on these RFEs, they look very benign. It's asking for proof of a bona fide employer-employee relationship. And really, you look at the documents and they're just trying to verify the existence of the employer and that everything is how you said it is, that you have an offer letter, that there is a valid EIN, that there is an employment agreement where you're working. They're also asking for the 983, which is kind of weird because it's not required to submit in the STEM OPT. But it looks very benign. They're looking for performance reviews, pay statements, personnel records, and it looks like they're just trying to verify this. It does note that if you're working for a consultancy, they want to have a list of clients' names and projects and the dates of employment. And it looks really simple, right? Okay, you asked for this, here's this. You asked for the performance review, here it is. You asked for timesheets, here it is. But we've seen some hangups on this, right, Emily?
Yeah, so we've been coming across, we do a lot of consultations with individuals with all types of immigration issues. And so we've been coming across more and more situations of denials after responding to this RFE for things that really weren't even raised in the RFE and that the student wasn't aware that there could be a problem based on what they're submitting. So one of the things that, although they don't point out in the RFE, they're talking about proving this bona fide employer-employee relationship and wanting basically employment documents. They're also using the information that you provide to verify that up to this point that you've properly maintained your F1 status. And part of that with OPT is not exceeding the unemployment limit. So for individuals who may have been employed, but in unpaid positions, which is allowed during OPT, if you just provide your pay statements and the documents that the government asks for, and without explaining that during this set time period, I was in an unpaid position and having supporting documents of that, the government looks at those documents and says, we see a gap in your pay. Therefore, if it exceeded 90 days, you've exceeded your unemployment limit, even if you were actually employed. And they're not going back and sending you a request to verify or for additional evidence. They're just denying it flat out. And that puts the student in a very tough situation because denials are hard to overcome. They take a long time to overcome. Your status is in limbo. You can't work anymore. You can't just automatically go back to F1 status. So what are some of the things that for the first 1 year of OPT, the employee should be following in order to be considered maintaining their F1 status properly?
Yeah, so, one, there's the notification requirements to the DSO and keeping them up to date on any changes, as well as the regular reports that you're supposed to submit. But I would also ensure that if I was an F1 student, I'm keeping my timesheets or my reports or emails, something to show that I am working. And if I can use a case study here from one that we had a consultation on a couple weeks ago and actually just filed a lawsuit on it this week, she had all the documentation that was asked in the RFE, but USCIS viewed it as a discrepancy because some documents said her employment start date was her OPT period, which was unpaid, which is allowed under the OPT regulations. And then they redid all the documents saying that her start date was months later when she was starting her STEM OPT, which was going to be her paid practical training because STEM OPT has to be paid. And USCIS says, whoa, you have documents here that say your start date was months and months later. We think there's like 200 days of unemployment, which is more than what is allowed. And why did this come about? She responded on her own with just the documentation with no, hey, yes, explanation as to, hey, I know some documents say this, but really we're doing a new employment letter because I'm now getting paid and it's a new position versus, my unpaid internship. And here's confirmation that I did that with the employer. And so she got a denial for the unemployment, which creates a lot of problems. Not only is she now ineligible for the STEM OPT, but she's out of F1 status. So I would, if it were me, be keeping records of those emails, keeping my training agendas with the employer, meeting notes, whatever it might be, that are dated to show, hey, I am actually working, even if it is unpaid. Because, you don't, especially if it's an unpaid position, you don't have those pay statements available to submit to USCIS.
Yeah. And so although the OPT and the STEM OPT should be a relatively simple, straightforward process compared to a lot of other immigration processes, students should be able to complete the majority of that on their own. I think most schools help guide them through that and what to file and when to file and what needs to be included. But if you do get one of these RFEs, you may want to consider talking to an attorney, going through your documents to make sure, even if you're submitting everything they're asking for, there isn't anything hidden in those documents that would give USCIS the wrong idea and make them, unfortunately, deny the application for something that you weren't even aware of was in the documents, like a gap in, the biggest one is showing a gap in your pay. They just automatically assume that that's unemployment time rather than questioning whether maybe this was just unpaid employment time, which is allowed. And then, go ahead.
With working with an immigration attorney or a professional or something, this gets back to law school 101 of issue spotting, right? And when we see these issues, we kind of know what to look for. Again, the client that we litigated for, I think she submitted everything that was asked to show that there was a bona fide employer-employee relationship, but it just was the way that it was, I guess, presented to USCIS made it look concerning. And so, hopefully we found a good solution for her. But I think it needs more sometimes than just, you asked for the employment letter, here it is. You've asked for performance reviews, here it is, and just submitting those. I think you need a little bit of analysis with those.
And there's another issue that comes up. It's not common, but it's also not uncommon when it comes to people who are filing the STEM extension, and that's the E-Verify component, that in order for you to qualify, you have to have the STEM degree, you have to do the 983 training plan, but your employer must also be an E-Verify employer, and you list that E-Verify number on the I-765 form. We've had cases we've come across where unknowingly the employer provided the wrong number, or the employer's E-Verify account, if you could call it that, was terminated or suspended for whatever reason at the time the employee unfortunately filed for the STEM extension. And there's not really a lot you can do to overcome that situation. So Stephen, how can someone who is getting ready to file their STEM OPT extension make sure that they've got the right E-Verify number and make sure their employer is actually in the system?
Yeah, so trust but verify, right? I would assume that if Emily gave me an E-Verify number, I would assume she's given me something that's good. But again, we've seen it where the company might not have even known there was issues with their E-Verify account. But you can search on E-Verify. There is an employer search. You can put in the employer's legal name, and it will give you the status of their account to make sure, one, that they have one, and two, that it's active, not suspended or anything like that. I encourage, the E-Verify number has to go on the I-765, so you get that. But I would encourage any student that is applying for STEM OPT to verify it on their own. And it takes all of 5 minutes to do, and can save you a lot of hassle. One of the things, and the reason Emily and I wanted to do this video, is fixing issues with STEM OPT it can be very problematic and lengthy, whether it is filing late. And we've written articles and done videos on that to watch the timing. USCIS is very unforgiving on that. Whether it's the E-Verify thing, USCIS is very unforgiving on that. Or in instances like we've seen where, hey, you give all the information about a bona fide employer, now they deny you for another reason in the RFE, issue spotting that. If you do an I-290B, it's going to take months and months and months, and you can't really do anything. And that is only being hopeful that they're going to take some leniency on it, or having to litigate it can take a couple months too, hopefully. So again, being proactive and finding these issues ahead of time, because look, that 2 years of STEM OPT, Emily, we know that's very valuable, especially when we look at an individual who's wanting to get on the H-1B lottery, or maybe going through the green card process with how long it could take, that they might need that full 2 years to bridge that gap. So, check the FEIN, make sure you're timely filing, and just when you get these RFEs, don't panic. They're common. I've seen enough of them over the last couple years to know, okay, it's not just one or two companies, it's all over the place. But, think through what you're submitting, and whether, look, of course, I want you to work with an immigration attorney. I think that's good. But if you're doing it on your own, look detailed at the documents, and maybe prepare a cover letter to explain what's going on. Hey, I did my initial OPT as an unemployed, and we've redone all the employment documents. Just something to kind of lead the horse to water here.
Yeah, I think people need to just think about it in terms of, you really only have one shot at this application, because if something goes wrong, this type of application, you don't get a chance to refile it, because by the time something has gone wrong, your filing window closes. Your OPT has already expired, or your I-20 is no longer valid for the STEM OPT. So make sure everything gets done properly the first time. If you get one of these RFEs, be very careful about what you're submitting, making sure everything shows how you qualify and how you've maintained your status during the prior year of OPT, so that you don't be in that hard situation where you end up with a denial. So thanks for listening. Hope you found this helpful. And as always, we'll be back with more videos to keep you up to date with all the latest in business immigration.
Thanks, y'all.